Well, good morning, Your Honors. Before I begin, can I say what an honor it is to be before you today. I am usually slugging it out in the trenches of the trial level. This is my first and maybe after today only opportunity to talk to you today. I hope I don't mess it up too bad. If I'm not asked back, I guess I'll know why. But just be patient with me if you would, and I appreciate it. I will say that seeing a few familiar faces makes it a tad less intimidating, not much. Okay, so why are we here?
Counsel?
Yes,
Would
ma'am.
you please say your name for the record?
See, they told me to do that, and I didn't do it because I'm nervous. Okay, my name is Adam Brown, and I'm here for Andrew Shirley in this case. So we're here today to basically answer three questions that were presented by the court. The first one has to do with whether or not the suspension of the requirement for registering your vehicle, the suspension of that was, the governor was able to do that under the Texas Disaster Act. Now, of course, I don't think that I need to go into much detail about the history of...
Counsel, I just want to ask really quickly, I know you're nervous and I apologize for jumping in, but at the trial level, was there an argument that the statute had been suspended by the governor, or was the argument that DPS was no longer enforcing these things?
Well, again, okay, so at the trial level, Your Honor, remember that we're dealing with a motion to revoke probation.
Right.
Which is
Not a motion to suppress, that's right.
It's a whole new animal, right? And
Right.
it even has a different standard that we're looking at. Yeah, so I think, again, I know the trial level attorney, he's very, very good. This was kind of, for all of us, it was kind of a nuance, right? It's something new. And so I think
Throughout the COVID thing, everything evolved. Like, yes, there was an evolving case.
It had to be flexible, absolutely. You know, I think where the gist of it is that they were trying to see whether or not the police department was enforcing the law, or whether they was going along with the suspension, right? And we're probably, I imagine, going to get into that because there's a good faith argument, and I know y'all are hopping to get to that point of it. But to answer...
Well, actually, I hadn't gotten to the good faith argument. I'm still just asking you whether the argument at the trial level was that the statute had been suspended versus whether the argument, or was the argument there, it's simply not being enforced. Because those are two different things.
Sure. I think the argument was that it was not being enforced by the, well, this is, okay, it's kind of a double negative. The argument was that the police department, despite the suspension, was still using it for probable cause.
Okay.
That's what it was. And then there was also some testimony, and again, I will admit, Your Honor, the testimony is a bit vague. There wasn't really a specific, well, did you know about the suspension? Did you just ignore it?
Right.
You know,
well, it's a revocation.
Right. What are we dealing with here? I think, honestly, Mr. Wells, who was the trial attorney, kind of saw something and jumped on and latched onto it, which is what they should do, right?
Yeah, right.
So, at any rate, that's what I think they were trying to figure out. Okay, so as far as whether or not this particular law or regulation, whatever you want to call it, was covered by the Disaster Act and was allowed to be suspended, I think the state and I are in agreement that it was. Okay.
Let me ask you, what is the difference between a regulatory statute and a statute?
Well, my interpretation of that is, I guess, and where it kind of goes to on this one is, what level does it rise to? Okay. In other words, I think as far as an executive order goes, requiring the executive order goes towards very serious and huge decisions under the Disaster Act. This one, I think, was more of a minor, just trying to keep people separated, right? Because you don't want them going into, we've all had to go get our...
I'm not asking about the justification for the suspension.
Okay.
I'm asking about the meaning of the phrase regulatory statute.
Okay. I would have to kind of look at that, Your Honor. I don't really have specifics on that. I'm sorry.
All right. And what provision of these transportation code statutes prescribe the procedures for the conduct of state business.
Okay, so you're talking about the state business.
I'm talking about the Disaster Act.
Okay.
And what it lets the governor suspend.
Right.
The governor gets to suspend provisions of statutes that prescribe procedures for the conduct of state business. These two transportation code statutes start out, a person commits an offense if, and defines these little crimes. How are those prescribing procedures for the conduct of state business?
Okay, well, again, I think that I don't really have an answer for you, Your Honor. I apologize. I don't.
But you would say they don't, right?
I'm sorry.
That I think your position would be that the governor did not have authority to suspend those statutes because they're not what Judge Keel said about the
Well, he
procedures.
would want the governor to have that
He would want the
authority.
governor.
No, yes, ma'am. No, no.
Right.
He would want the governor.
Sorry.
So if the governor can suspend these statutes,
Greg's your
then
buddy.
the law enforcement can't enforce them. That's your position, right?
I'm sorry. repeat
If the
yourself.
governor gets to suspend these criminal statutes,
Yes,
these
ma'am.
statutes defining these Class C misdemeanors,
Yes, ma'am.
then the police had no right to stop your guy for violating these particular statutes.
That's correct.
All right.
Yes, ma'am.
And therefore, they couldn't do whatever happened.
Yes, ma'am.
It
That's
should have all been suppressed.
Yes, ma'am. And then I guess what flows from that is whether or not the police, what duty do the police have to know that, right, that it's suspended, and then apply the law at that point. Okay, so that's something that we're also going to argue today as well. But to kind of carry on.
But you can't say how these statutes have anything to do with the conduct of state business or procedures prescribing the conduct of state business or how they're regulatory statutes. That's not part of your argument here today.
That is not, Your Honor.
Okay.
But yes.
That's
yes,
all
ma'am.
right.
So I have one more question
Yes,
that's
sir.
also kind of precatory, and that is, you know, in your brief, you cite Article 1, Section 28 of the Texas Constitution. The provision that says that no power of suspending laws in this state shall be exercised except by the legislature. So how do you get beyond that? How does your argument proceed beyond that point, knowing that this statute seems to do exactly what that constitutional provision in the Bill of Rights of our Article 1 of our Constitution, how does your argument go any further beyond that constitutional mandate?
Well, I will first say, Your Honor, I am not up here to say that I am an expert on Texas constitutional law by any means of the stretch of the imagination. However, I will say that, again, I think that we need to look at the circumstances surrounding what was going on. This wasn't just a situation involving the great state of Texas. This was a worldwide pandemic, and things had to be done. I'm sorry.
But your argument about why the police erred by stopping this person doesn't have to do with the pandemic. It has to be related to some legal requirement, right?
What-
I mean, you're painting this picture about the worldwide pandemic, and I think everybody knows that was happening. But really, this is about a more narrow issue about whether or not the governor's decision to suspend certain laws was effective, right?
Well, okay. I think what I'm saying is that the state and I both agree that this particular regulation, that being the registration of your license, okay, falls under something that the governor can do an executive order and suspend. Okay, we're both in agreement with that. All right. Okay. So if that's the case, then the whole argument comes down to whether or not when my client was pulled over, was there some sort of duty from the police officer to say, hey, I know that this has been suspended. I know, as does the rest of the state of Texas knows, we don't have to register our car. we're relying on that, and we're driving our car, yet this particular police officer said, Governor, whatever, we're going to pull over. And I think it's interesting that the state even concedes, well, had there been an executive order filed with the Secretary of State, suddenly the light switch would go off, right? And all the police officers would know about this, and all the police officers would not pull people over, which is not, it's just not feasible, right?
Counsel,
So, yes.
sorry, I'm sorry to interrupt you. Please continue your point. Please.
Oh, no, that's, okay.
Well, I was just going to say, like, isn't really this issue, and we're getting these big issues, but isn't really the issue in this case whether the state proved by preponderance of the evidence that there was an evading arrest that occurred because the defendant fled from an otherwise lawful detention? And the facts of that were, they looked on the dispatch, they saw that his license was expired, and they stopped him. Now,
His license or the?
or his registration.
Registration.
His registration was expired.
Yeah.
And they see that and they,
Well,
well,
if
they're
that
going to
law
pull him
was
over.
suspended, how would they have the authority to even pull him over?
Isn't that really the issue? Isn't that really what we're here to focus on, is whether or not the state proved by preponderance of the evidence one of the grounds for revocation?
I agree, yes.
Yeah, okay.
Absolutely.
Thank you.
Yeah, it is. And of course, our position is, just as Judge Keel was saying, if the police officer, as they should have, knew that this particular law or requirement had been suspended. Okay, then he wouldn't have the ability to pull it, even if it shows up on.
That's a very good point, because there's a case called Herring versus United States where the police officer saw a defendant he thought might be involved with crime and have a warrant out for him, and they double-checked with a neighboring county to see if there was a warrant that had been issued. And they did, and sure enough, they got a report from the clerk that there was a warrant that had been issued for this defendant's arrest. They arrested the defendant only to find out that the warrant had been recalled and that they were wrong. And it seems pretty analogous to this situation, which is we got expired tags, but then we find out, well, it's suspended. The law has been suspended.
I would respectfully disagree, in the sense that a warrant, and whether or not a warrant is active, that's flexible, that's day to day, right? I mean, we don't know if that's active, when it's not active, things like that. This was actually something that was executed by Governor Abbott, put out on a press release, sent to Department of Motor Vehicles. Department of Motor Vehicles then said that they sent out a notice to law enforcement. The governor said that he would work with law enforcement to educate them on what's going on. Now, look, we can talk law and we can talk reality. And the fact of the matter is that in reality, every single day before these police officers go out onto the streets, they are briefed. And if you tell me, or you really think, that one of the largest police departments in the nation has a direct order from the court, from the governor, saying you cannot enforce this law, that they are not going to be briefed on that. And the fact of the matter is that they admit in the record that they knew about
What
this.
if this law had been repealed
Right.
and the police officer didn't know that it had been repealed and he sees an expired sticker? And would we then say, well, that was good faith and so it was okay?
Right.
Or would it really even matter? It wasn't the law.
Right, Judge.
So
And
does a suspension have the effect of nullifying this offense and just nullifying any effort to enforce it?
while it's suspended, I would say yes.
So the meaning of suspension is to completely do away with it.
Do away with it for a time
So
period,
it doesn't
yes.
really matter if the police officer knew what Governor Abbott said.
Well, it does if it's going to be used for probable cause.
Well, if the law was suspended and he was wrong about the existence of the law did not exist, then he couldn't enforce it.
Correct.
Right.
I agree completely, yes.
Okay. So it really comes down to whether Governor Abbott had the authority to suspend this law.
Right, and now, of course, I would say he does, and I think the state agrees with that.
Yeah, well, I think that's a pretty incredible position for you both to take, given the wording. Given the wording.
I just am glad we're in agreement on something.
He still has a chance to come up after.
Exactly. He probably has something to say about this, Judge.
The wording of the Disaster Act is very specific.
It is.
And seems to have nothing to do with when a person commits a crime, that's what these statutes are about. These a person commits an offense. The Disaster Act is talking about the conduct of state business, procedures for conduct of state business, regulatory statutes.
Well, I mean, I guess we could split hairs, Your Honor, about, this being.
Do you think I'm splitting hairs by looking at the language of the Disaster Act?
No, I'm saying that I'm splitting hairs with you, which I've done on many occasions, actually, in the past. But point being is, Your Honor, is that I think that the way that the governor looked at this is that it was.
I don't care how the governor looked at it. I'm asking about what the statute says.
Okay, well, I would interpret it as saying that this is something that is administrative in nature, I guess. In other words, it's a registration that you do, you pay money, it goes into the coffers. Whether it's a crime, it is technically under the transportation code. You can get ticketed for it, you can get fined for it. But I think that the way that the governor was looking at it and the way that I interpret it is that way.
I mean, nobody said anything about the actual process of getting the registration during the pandemic, which I totally understand what Judge Keel is saying, but the reality was, number one, you have to get your car inspected first to get a registration. And trying to get your car inspected during the pandemic and the quarantine really was like an act of Congress, trying to find somebody who'll get in your car and test it and go through all the mechanics of that. And then you have it inspected, and then you have to get to the registration office hoping that somebody's actually working there to do it. Was that ever presented in the hearing? Like, you can't even get your car registered if you wanted to.
Well, it was not.
I
I didn't. I couldn't get it done.
Well, remember,
I didn't drive.
I was thinking about this, and I remember bringing home bags of groceries and wiping them down with Clorox.
Right.
Crying out loud. It was just kind of crazy. And you're right. Of course, again, as I was saying before, this was a motion to revoke hearing, and so I don't think that they went into detail about that, but I am certainly aware of the difficulty.
I don't know if that justifies what Governor Abbott did or not. I'm sure it was in the back of somebody's mind that we've got all these millions of people in the state of Texas that can't even get their cars inspected to get them registered.
And I think the focus, again, was trying to keep people distanced, right? And anybody that's gone and gotten their license or registration done, you're right, it's a two-step process. You get inspected, and then you go downtown and you do that, and you get the little ticket. Yes, absolutely, and I think that's what they were trying to do. And again, in the midst of the pandemic, everyone's just trying to do the best that they can at this point. So that's all I've got. It was, again, a great honor to talk to y'all. Thank you.
Thank you, Counsel.
Good morning. My name is Zachary Gibson. I'll be representing the state of Texas. Presiding Judge.
God, you're going to need to speak up, buddy.
Sorry. Presiding Judge Keller, may it please the court. My name is Zachary Gibson for the record. The facts of this case are basically uncontested. The appellant was driving a vehicle which had an expired registration. I don't think anyone disputes that. Prior to the appellant's traffic stop, the governor issued a press release claiming that he was waiving the requirement that people renew their vehicle registrations due to COVID. The dates given in the press release.
Mr. Gibson,
Yes.
what's the difference between a statute and a regulatory statute?
That I am actually not sure what a fine line would be. I believe regulation in Black's Law Dictionary just means to control by rule or restriction, which I think most statutes would meet that definition. As to your question to Mr. Brown about whether this was involving state business, the reason why the state decided not to contest that as an abstract proposition, we contest whether an officer was legal in making the stop. We believe it was a legal stop. But as for whether it involves state business, it is true that it does say it is an offense. But then what it's an offense to do involves state agencies. You have to go to a state agency and use them to renew the registration. So yes, it involves, like, if you're trying to keep staffing minimals low in person at state agencies, required staffing at the places where you need your vehicles registered, even if you're doing it by mail, that does affect the conduct of city. It is a statewide requirement.
So do you think the governor had the authority to do that? That's the million-dollar question, right?
Well, on one of the grounds, as an abstract proposition, we do believe that he does.
On the ground on repealing or not enforcing the car registration?
Yes, and that is simply because what was at issue here were an agency of the state being required to issue a registration. You also have, whenever you go get your car inspected, I think this is common knowledge, that first of all, that requires in-person contact. So that's going to involve the COVID pandemic, but then they also run it through a state database.
Counsel, but under the Texas Constitution, what's your authority for saying that the governor had the authority to suspend these sorts of laws?
Well, under the Texas Constitution, it does say there is no power of suspension. That dates all the way back to the English Bill of Rights. But it is allowed in modern jurisprudence for the legislature to do targeted delegations of its authority to executive agents. So long as there's prescribed procedures. I understand that the grounds of review are not about the constitutionality. I included briefing on the constitutional issue in case that's teetering in the back of the court's mind as some sort of a constitutional avoidance type of an issue. But we believe this is a narrow targeted delegation. The issue between, so first of all, let me just address two preliminary points that really do matter to the state here. Number one, as the case is currently before the court, and we talk about this in our brief, we do believe the best course of action for the court is to improvidently grant this. These three issues that are in this case, they are interesting issues. Maybe be a great law review article. In my brief, it's pretty close to the length of that. But none of them were addressed in the court below. There is not a single sentence about this. This was addressed on preservation. Now, the appellant might think that's wrong, and let's assume for the sake of argument that is wrong. Preservation is a systemic requirement under Texas law. If he doesn't get that preservation holding below reversed, he is done. And he has not challenged that here with the ground of review. I know he talks about it in a footnote how he thinks it's wrong. So we think this should be improvidently granted.
Counsel, what is the preservation argument?
The preservation argument is very simple. Number one, I think our best authority for this issue is the Garcia case. Again, this wasn't talked about below either. Usually under Fourth Amendment, when you're talking about that, you do have a preservation requirement. Here we're dealing with sufficiency of the evidence to support a revocation simply because the legality becomes a substantive element. But this court recently in the Garcia case said just because you talk about something under the guise of sufficiency doesn't necessarily mean a preservation requirement is not required. We accept sufficiency to review guilt innocence determinations in a jury trial or a bench trial. We concede you do not have to preserve that under Texas law. In federal court they do, but it's under Texas law we concede that. But here it's a judge-only proceeding. Argument is made to a judge, and it's a judge being reviewed on abuse of discretion. And the unfairness of not having a preservation requirement to the trial judge is evident in this case. Here the argument to her, as she understood it, it's not just about how he articulated it. We cite the areas where the judge is saying, here's my understanding of their argument. DPS had a policy of not issuing tickets, and she thought that was their objection. Now, if that's true, you can make that objection, but that is clear under cases like Wren versus United States that policy enforcement decisions don't affect the Fourth Amendment. So now, by not having a preservation requirement, you can then do a bait and switch on appeal. You can say, well, actually, the law was different. Now, when you don't have a preservation requirement, you can do that. But for all the reasons in the Garcia case, when you're in a case like this where you're dealing with an appeal from a judge-only proceeding, it's a revocation hearing, you can articulate to the trial court, hey, I think this is not a valid, they haven't proven their case because of X, Y, and Z. And he made an argument like that. It didn't include this argument, but he made it like that. Number two, it's not preserved. We talk about in our brief, her understanding was this was a policy enforcement of DPS, not a, he does use the word suspension, but he's using it in a way that led her to believe, and I think everybody in the room to believe, that it was a DPS policy, not suspension as it goes back to the Stuart Kings, where that which is unlawful becomes lawful and vice versa. It was that understanding. As to the merits, on the first question presented, we do believe this fits the definition. Now, it may be a close case. I accept there's not a lot of litigation about this. The split amongst the lower courts of appeals, which my understanding is many of these cases are still pending down the hall in the Supreme Court of Texas, is about whether the governor can suspend a local law. Does it have to be statewide? That doesn't really apply here. This is a statewide law.
What
Yes, ma'am.
provisions of these two transportation code statutes regulate the conduct of state business or prescribe procedures for the conduct of state business?
Well, because, and of course technology is always failing on me, I had the text ready to go. It would be the section, I believe it's the first one cited in the first ground, 502407, and it says that it is a person commits an offense after the 5th working day, the registration for the vehicle expires, and then I'm paraphrasing, he drives it on a highway. That yes, it's true that regulates what the individual is doing, but to enforce this, to make this regulation enforceable, this state agents, state employees, state offices are all required to make this occur.
Well, couldn't the governor have suspended the provisions that regulate the way they do that, the way they issue the registrations, the way they accept the applications for them, the way that they do their business, not what the individual is doing here under these.
I very well believe that may have been the intention, because the actual press release lists more statutes.
Regardless of the
Yeah.
intention, there are statutes that regulate the way that the transportation department operates, aren't there?
Yes, ma'am.
Yes.
Well, but that might
He
be,
could have suspended those statutes, right?
I believe his intent was to do some of them, but to answer your question, there may be a fine conceptual distinction between, you have a law that makes it a crime to violate a regulation, and if you have the authority to suspend the underlying regulation, but not the statute making it a crime to violate the regulation,
No,
that may
I'm
be.
saying the way that they issue. He could have suspended the provisions about the way they issue the registration, or the way they require you to apply for it. He could
Yes,
have done a
ma'am.
lot of things besides just saying, these criminal laws are suspended.
Yes, ma'am.
That would have fallen under the Disaster Act, his authority under the Disaster Act.
Those would have certainly been clear applications, perhaps? Yes, ma'am. As to the second and third issues, and that was the dispute below in the Court of Appeals between me and Mr. Brown, and really our biggest problem with all of this is that the argument goes something like this. On appeal, this gets past preservation, on appeal, take judicial notice of the press release, so that's probably a legislative fact, but then make that legally operative text. Now, that's a very unusual argument, and the reason why it isn't counterintuitive is that Texas has a very prescribed way of issuing executive edicts. And an executive order, I'm using that in a generic term. It could be labeled a proclamation. Governor's required to file that. That gives notice to the public and to the officers. Here, the argument is state law changed. It was not just non-enforcement, but state law changed. And our biggest problem is you're saying the officer was supposed to hear, apparently through the news, there's been this change, and then go around and then change his enforcement decisions, what he understands probable cause to be, and there's never been any legal instrument filed that would change state law. I know you mentioned repealing a bill. Well, the Disaster Act does say that these regulations have the force and effect of law, and that provision giving him the authority to issue these under this chapter is presumably there so he can do things that change state law. And that's what they're claiming happened here. State law underlyingly changed. For this period of time, it wasn't just prosecutorial discretion which allowed you to drive down the highway. It was that the state law changed. And that is quite unusual. I mean, I had to go back to the 1890s where it talked about, we're going to stick to the four corners of a proclamation and things of that nature. On the third ground of review that was granted, our argument is very much this, which is we don't believe state law changed. There was no executive order, no proclamation, no regulation was filed. And again, it's under Hine versus North Carolina, or Heinen, I've heard that said both ways. It's an objectively, legally well-informed officer. So if you have a state statute, even if they didn't read it, they're on the hook for it. Conversely, if something is not the law, we presume that they know that as well, even though the officer on the scene probably doesn't. He's just going by what his supervisor says. Here, even if this court under grounds 1 and 2 says, well, the governor has the authority and you don't have to file an executive order or do anything in the official edicts of the governor to suspend an actual statute, we can still win on ground 3, which would be the narrower ground, and avoid some very difficult questions of executive power by saying, well, a reasonably trained officer, an objectively reasonable officer, hearing about there's been a requirement that DPS isn't going to issue tickets. I've heard about it in the news, but there's been no statute filed. An objectively, legally well-informed officer could say, this traffic stop is still lawful. And that, we believe that's actually the correct legal answer with no executive order. But it is certainly the way to bypass some very difficult questions of executive authority that are not necessary to the disposition of this case. If we went on ground 3, grounds 1 and 2 can just be assumed, and it disposes of the case.
You would assume what under ground 1?
Well, you could assume, for the sake of argument, you wouldn't hold that, but you could assume the governor has the authority. You could assume even Mr. Banks' argument. He doesn't have to issue an executive order. But then the question is, because that is such a novel introduction in Texas jurisprudence, to have no executive order, no proclamation, no official act filed, you can then still decide the stop is lawful. An objectively well-informed, legally well-informed officer could come to that conclusion.
But even if the governor had issued an executive order and jumped through all the hoops in the world,
Yes, ma'am.
how in the world are these two transportation code sections that say a person commits an offense if, how are they prescribing procedures for the conduct of state business? Point me to the provisions that prescribe procedures for the conduct of state business.
Well, first of all, the state would certainly win under this argument, so I don't want to contest it perhaps too hard, but I don't have anything, new to say about it other than what I've already said, that you're dealing with.
I guess I
You're
didn't
dealing with-
hear you point to the
Sure.
procedures.
Well, the procedure, so the actual transportation code just says it makes it an offense, but then what it makes an offense, so this is 502-407A, a person commits an offense, and then 1, operates on a public highway during a registration period, a motor vehicle that has attached to it a license plate for the preceding period, and it's no longer valid, which is A2. Now that involves state business. You cannot get your car registration renewed, your driver's license renewed, without state agencies involved. I mean, if you live in Harris County, I don't know if inspections are required in all counties, but if you live in Harris County like me, you have to go and physically have your car inspected for the emissions test, which then requires them to use a state database to then enter the information. So state agents are involved in what has to be done for a person to comply. If you were to shut down the government's regulations that make this occur, but then leave this in effect, you would have a statute that would be impossible for people to comply with. So it does involve state business. Our contention has never been with that. It's been what an officer would think, that this could be prosecutorial discretion. And a lot of things are done that way. There are a lot of things, I mean, marijuana diversion in many counties is understood by most officers follow it. But if push comes to shove and you have a marijuana case based on the smell of marijuana, just because you had a policy of prosecutorial discretion doesn't mean that the probable cause based on the violation of the statute is gone. It's a statute that controls.
Counsel, does the governor's order, would the governor's order say that, have the effect of saying that the registration was no longer expired?
Correct, and that, well, I mean, this is part of the problem with not having a legally operative text and relying off of a press release. This issue came up, a similar problem in the expiration of the driver's license things and the Attorney General opinion that's cited, which is, well, how do you deal with the federal regulations which say, well, what's your expiration date? And it has one that's lapsed. The answer is I am not sure what a legally operative text would say. It could perhaps say all licenses are hereby renewed to an X date in the future.
I just want to know what
Sure.
the governor said. I mean, in this case, and what you're relying on to say that what the governor issued had the effect of saying, even though your registration says it's expired, it's not actually expired.
Well, let me be clear about that. I was only conceding the very first point, which is an abstract proposition. Would this statute fall into that? That's a question that the court added. We are not conceding that the press release, which I have here, did that in a
That's
legally
fine.
operative sense.
Say it was legally operative.
Sure.
Then would that press release of what the governor said have the effect of saying that even though your registration is expired, it's not actually expired?
I am not so sure that it would, again, back to my point about a press release as operative text, because it just says the following regulations and rules are suspended under the governor's disaster declaration. Then it lists the sections that are affected, and then that's all it says. Now, usually in these cases, there are several press releases on the website where they'll have a press release that hypes up what the governor's doing, then they'll have a link to legally operative text.
Does it, okay, I think I understand where, and I'm hoping that I understand what Justice Slaughter is saying. Is the suspension suspending the offense, or is it suspending the registration requirement?
First of all, the press release actually doesn't have legally operative date, so I would say if this were a legally operative text, it would have a lot of problems being enforced in court. It could just go on indefinitely. The dates mentioned in the brief, I think, come from like a DPS website, but the press release does mention 502407, which is what makes violating the other provisions criminal. So it's a case where you have regulations prescribing what the state has to do.
So it's suspending the registration requirement, but it's leaving the statute that says it's an offense if this.
I assume it's not intending to, because it also lists a statute that makes it an offense.
Okay.
It does. So it lists regulation. So that's why we're saying the very first question the court granted argument on, regulatory statute doesn't have a lot of interpretation under the law, or what exactly this means. It does seem to be something that prescribes state business. State agencies do this. But then whether this is legally operative text, and we're now at the CCA. This is also my first time here. It's very nice to be here, as Mr. Brown pointed out. We still do not have what we would usually have in this case. Usually you'd go to the Texas Register and just look and find it. I read 13 sub-volumes of the Texas Register trying to find this. And this was not long before the brief was due, because I had just assumed whenever I was working on this case in the Court of Appeals that they'd filed something. And I just kept looking and looking and looking and clicking and Googling, and it's just not there. And again, that's why the briefing in the Court of Appeals, our main argument here, if the court wants to reach the merits, and we think dismissing this improvidently granted is the best thing to do with this case for the procedural problems with it. If the court doesn't just dig the whole thing, dismiss is improvidently granted. Right. I don't mean anyway, if it doesn't, we think then the best path, they would just need to reverse on preservation. If this court disagrees with that, vacate and remand to address the 3 grounds that were granted, because none of that's dealt with in the opinion below.
I have one more question, if you don't mind. I think I recall on about page 2 of the lower court's opinion, Court of Appeals, the court said something about maybe there was another officer who told the detaining officer that there was another reason to pull him over because he had failed to use a turn signal. Yeah. And so I don't know if the trial court made any findings of fact about whether or not that was true or not, but does that constitute any kind of an impediment? I mean, if it is true that there's an alternative basis to justify the stop, then are we just arguing about a potential advisory opinion that we might issue here?
Well, there is a problem, if I can just answer this fully, there is a problem with an advisory opinion, going back to my beginning comments, because if you address these 3 grounds that you granted on, and you don't reverse on preservation, then the whole thing is just dicta. But number 2, on that ground, the testimony was he didn't put on his turn signal before leaving a private parking lot. That may be true, but that's not a traffic offense. I think that was dealt with below, we conceded at I think 2 of the courts of appeals have looked at that. There's just no requirement when you're leaving a private parking lot. If he'd done it on a highway, maybe, but there wasn't. Okay. There just wasn't. Thank you all very much.
despite the fact that I am a firm believer in get in and get out, I'm going to mention a few things. I only have 2 minutes, and I'll be very brief. I wanted to answer your question. He answered it correctly. Yes, down at the trial level, I believe they determined that that was not an offense. In addition to that, it was kind of a weird thing because a plainclothes police officer actually saw that, radioed, I assume, or contacted a police officer in a shop who then pulled him over. So that's what happened. I would like very briefly to talk about the preservation aspect of this that was brought up. I would argue to the court that a couple of things. Number one, it's interesting because we've almost got a perfect storm here because the underlying crime is evading, where it's necessary to have a proper detainment before you can move on. So it's more than just probable cause. It's actually part of the statute requirement for the state to prove that the offense was committed. So I think that's very, very important because it was brought up at the trial level. They were specifically asked about it. I'm not really sure where the state thinks that error was not preserved. It was specifically addressed. It's up to the
Counsel, didn't I actually ask you that question at the very beginning? The argument below was whether DPS was enforcing this, and then on the appeal, it was whether the governor has the authority to suspend. And those are two different arguments, and that's, I think, what they're getting at.
Yes, I would agree with that, Your Honor. If I did not make that clear before, I agree with that. So at any rate, again, it's up to the burden's on the state to prove that.
Yeah.
And so that, we would say the preservation was there. Again, it was a thrill to be here today, folks. Thanks.
Thank you, counsel.